Bahrain's law on the protection of personal data entered into force on the 1st of August 2019. The law aims to regulate the processing of personal data by data managers and grants numerous rights to data owners, including the right to have their data protected from disclosure to third parties without their consent, the right to object to the processing of their personal data for direct marketing purposes, and the right to send a written request to the data controller for correction or erasure of their data. Lawful bases for processing are similar to those under the EU's GDPR and include data owner's consent, performance of a contract with the data owner, carrying out of legal obligations, and legitimate interests. As per a resolution issued in October 2019, the Ministry of Justice and Islamic Affairs was established as the body responsible for exercising the duties of the Data Protection Authority. Penalties for violation of the law include imprisonment not exceeding 1 year and a fine between €2,400 and €48,000 for, among other things, transferring data outside the Kingdom of Bahrain without approval of the authority or without the consent of the data owner, and for processing sensitive data without the data owner's consent. Under the law, data controllers are required to notify the DPA before proceeding with data processing, as well as obtaining prior permit for some forms of data processing, such as automatic processing of genetic and biometric data. Permit request is expected to be responded to within 30 days by the DPA, and a failure to respond is to be taken as an implicit rejection. The law also suggests that the relationship between data controllers and processors shall be bound by a written contractual agreement. Such an agreement should state that the data processor shall only conduct data processing in accordance with the instructions of the data controller, and shall bind the data processor with the same duties and obligations as the data controller with regards to data confidentiality and security. Whilst there is no requirement for compulsory appointment of DPOs under the law, the DPA may issue a decision which requires certain categories of data controllers to appoint a DPO. In addition, the law does outline the main duties and responsibilities of the DPO, which bear similarity to those under EU data protection law. DPOs are also required to enroll in the DPA's Register of DPOs in order to be accredited to assume the role of a DPO and renew their registration annually for a fee. The law also imposes an obligation on DPOs to notify the DPA of any violation or breach committed by the data controller. Appointment of a DPO would also exempt organizations from certain notification requirements related to automated processing. To continue researching key compliance requirements in Bahrain, use jurisdiction dashboards to quickly access the latest regulatory developments and best practice from leading experts.